Hello viewers, myself Dr. Sanyogita, Assistant Professor, Himachal Pradesh University, Shimla. Today I am going to discuss the topic Critical Appraisal of Rule of Law. First of all, introduction of the topic. The rule of law is a fundamental concept in any democratic country. As we know, India is the largest democracy in the world. It is no exception to the rule of law. The rule of law is a principle that asserts that everyone is subjected to the same set of rules. No one is above the law, and law should be applied equally and fairly to all the individuals. Not only the individuals, but all the institutions and the government are subject to the same laws. Rule of law is enshrined as a core value in the Constitution of India. However, the rule of law concept has also faced certain criticism. Let us first talk about the origin of the rule of law. The origin of the rule of law can be traced back to the ancient Greek philosophers, Plato and Aristotle. Political and legal philosophy has strongly emphasized the concept of the rule of law ever since Aristotle separated the rule of law from that of any individual in the 4th century BCE. Though the origin of this doctrine was attributed to Sir Edward Coke, he introduced that king is under God and the law. The concept was further developed by the influential thinker A.V. Dicey in the 19th century. So, it would be appropriate to discuss the views of Dicey. As he is exponent of the concept of rule of law, the three main tenets of Dicey's groundbreaking book, Introduction to the Study of Law of the Constitution, were used to define the rule of law in detail. First is the supremacy of law. It means that no one is punishable except for the distinct breach of law established in the ordinary legal manner before the ordinary courts of the land. Dicey went on to say that in situation when the law is supreme, discretion has no place. He claims that discretion is connected to arbitrariness. According to Dicey, wherever there is discretion, there is potential for the government to act arbitrarily and with discretionary power, endangering the people's right to legal freedom. The second important pillar of Dicey's concept of rule of law is equality before law, which means no man is above the law. In other words, every man, irrespective of his rank or position, is subject to the ordinary law and jurisdiction of ordinary courts and not to any special court. According to him, special laws and special courts is a threat to the principles of equality. Therefore, he is of the view that there should be same set of laws for all the people and should be adjudicated by the same civil courts. The third pillar of Dicey's concept of rule of law is predominance of legal spirit. According to Dicey, for the prevalence of rule of law, there should be enforcing authority, and that authority he found in courts. First and second aspect of rule of law apply to Indian system, but the third aspect of Dicey's rule of law does not apply to Indian system because he asserted that the courts of the law and not written constitution are the ultimate protector of an individual's fundamentals. Overall, Dicey in his enunciation of rule of law emphasizes that the lack of arbitrary and discretionary power, equality before law, and legal protection of fundamental human rights through courts. These ideas are important and relevant in every democratic nation today. But in developing nations, national security is assessed from various dimensions. Terrorism today has become the greatest threat to the world peace. and particularly to the India's national security. For the management of the internal security, multifarious challenges are being faced by India. To effectively secure the life and liberty of its citizens against terrorism, certain national security laws giving wide discretionary powers to the executive are needed, which may seem to be incompatible with the concept of the rule of law. The term rule of law is nowhere defined in the Indian Constitution, but the rule of law runs like a golden thread through our Constitution. The preamble of the Constitution of India sets out the people's aspirations, hopes, ideals, and the results they desire. Preamble itself speaks about the justice, liberty, equality, and fraternity, and leaves us in no doubt that the Constitution embodies a thick version of the rule of law. Part 3 of the Constitution contains the fundamental rights of the people. No law made in India can take away or abridge the rights conferred by Part 3, and if it does so, it is void to the extent of contravention. Article 13 of the Indian Constitution upheld the doctrine of rule of law in India. The laws defined under Article 13 as rules, regulations, bylaws, and ordinances can be struck down if they are contrary to the Constitution of India. The significant derivatives of the rule of law is judicial review. Judicial review is an essential part of the Constitution of India. It not only protects the constitutional principles, but also checks the administrative actions and its legality. All actions of the state authorities and bureaucracy are subject to the judicial review and are accountable to the courts for the reasonableness of their actions. Article 14 provides the state shall not deny to any person equality before the law or equal protection of laws within the territory of India. The direct connotation of these words provided under Article 14 is that the law is supreme and there is no scope of arbitrariness, as everybody is governed by the rule of law. Law treats everybody equally without any biases, which is the basic requirement of the rule of law. Article 15, 16, 19 and 21 further strengthen the ideal of equality by incorporation of protective discrimination as a means of ensuring equality amongst the equals. The fundamental right to life and personal liberty is provided under Article 21 of the Constitution. This article postulates that no person shall be deprived of his life and liberty except by the procedure established by the law, thus making the law supreme. Such right also guarantees that no person will be convicted except for the violation of the law, which is in force at the time of commission of the offence and not for any other act. The principle of double jeopardy and self-incrimination is also well recognized in the Indian Constitution. Fundamental rights are universal and inalienable rights and can only be protected by the state that respects the rule of law. Fundamental rights can be enforced under Article 32 and 226 of the Constitution. Judicial interpretation of the rule of law. The Indian Constitution is the supreme law of the land, and every law has to be in conformity with the provisions of the Constitution. The Indian judiciary is the guardian of the Constitution. If any law is in violation of any of the provisions of the Constitution, it shall be declared void. The rule of law is the fundamental principle of governance in any civilized democratic country. It is antithesis to arbitrariness. The Indian judiciary through various judgments, has evolved the concept of rule of law in India. It has modified the application of the rule of law from time to time to meet the exigency of the situation. There are number of cases where the concept of rule of law was discussed and came into light. Some of the important cases are S.P. Gupta versus Union of India, where Justice Bhagwati noted, if there is one principle which runs through the entire fabric of the Constitution, it is rule of law. And under the Constitution, it is the judiciary which is entrusted with the task of keeping every organ of the state within the limits of law, and thereby making the rule of law meaningful and effective. In Keshwananda Bharti versus State of Kerala, the Supreme Court said to have declared that the rule of law is part of the basic structure of the Constitution. This conclusion was arrived at by a subsequent decision of the Supreme Court. In Indira Gandhi versus Raj Narayan, Justice Matthew wrote perhaps the first exhaustive analysis of the rule of law concept in any Supreme Court judgment. The learned judge noted, there is a genuine concept of rule of law, and that concept implies equality before the law, or equal subjection of all the classes before the ordinary law. Justice Radhakrishnan, speaking for the Constitution Bench in KT Plantation Private Limited versus State of Karnataka, gave his analysis that rule of law as a principle contains no explicit substantive component like eminent domain, but has many shades and colors. Violation of the principle of natural justice may undermine rule of law. So also, at times, arbitrariness, proportionality, unreasonableness, etc. But such violations may not undermine rule of law so as to invalidate a statute. Violation must be of such a serious nature which undermines the very basic structure of our Constitution and our democratic principles. Justice Iyer and Justice Bhagwati said in I.R. Kolo versus State of Tamil Nadu that fundamentals such as secularism, separation of powers, equality, and also judicial review are the basic features of the Constitution and essential elements of the rule of law. On one hand, judiciary has established the importance of the rule of law, but on the other hand, found the need of exceptions to be engrafted on these ideals of rule of law. In various cases, Indian judiciary has observed that rule of law has different facets, and because of its indiscriminate use, has meant different things to different people at different times. Probably that is what prompted Sir Ivor Jennings, the famous constitutional historian, to characterize rule of law as unruly horse. In Indira Gandhi versus Raj Narayan, Justice Matthew wrote, if the rule of law is to be the basic structure of the Constitution, one must find specific provisions in the Constitution embodying the constituent elements of the concept. I cannot conceive of rule of law as twinkling star up above the Constitution. The equality aspect of the rule of law and of democratic republican is provided for in Article 14. To be a basic structure, it must be a concept having its habitat within the four corners of the Constitution. the provisions of the Constitution were enacted with a view to ensure the rule of law. Justice Radhakrishnan in KT Plantation Private Limited versus State of Karnataka further said that rule of law as a principle can be applied by the constitutional courts in the rarest of rare cases only, in situations we have referred to earlier, and can undo laws which are tyrannical, violate the basic structure of our constitution and our cherished norms of the law and justice. This paragraph is indicative of the confusion about the status and practical use of the rule of law principle in the constitutional framework. Justice K. Ramaswamy in case of S.R. Bommai versus Union of India observed, rule of law has been chosen as an instrument for social adjustment in the event of clash of interests. In A.K. Gopalan versus State of Madras, Justice Patanjali Shastri, explaining the necessity of preventive detention laws giving wide discretionary powers to the executive, said, this sinister-looking feature, so spiritually out of place in democratic constitution, which invests personal liberty with sacrosanctity of fundamental right, and so incompatible with the premises of preamble, is doubtless designed to prevent the abuse of freedom by antisocial and subversive elements which might imperil the national welfare of infant republic. The judiciary, through its intervention over the years, has tried to build in an element of reason and fairness into all formal decision-making procedures, and has succeeded to some extent. To cope up with the need of practical government, several exceptions have been engrafted on these ideals of rule of law in the Constitution of India. For example, existence of wide discretionary powers to the executive. President and governor of this state are given wide discretionary powers in relation to certain matters under the Constitution. Under Article 72 and 161 of the Constitution of India, the President and the Governor respectively have prerogative to grant pardons, reprieves, respite or remissions of punishment, or to suspend, remit, commute the sentence of any person convicted of any offence. Article 85 of the Constitution of India provides the President with discretion in relation to the prorogation of either House of Parliament and the dissolution of the House of People. The Governor, on the other hand, has discretion in sending the report of the President under Article 356 of the Constitution and in reserving the bills for consideration under Article 200. Police, which is a part of executive, is given wide discretionary powers of arrest without warrant in case of cognizable offences. Criminal courts in India have wide discretionary powers in providing sentences. Immunities and privileges. Under Indian Constitution, equality before law does not mean that power of a private citizen should be same as public official. Public officials like ministers, local authorities, public officers and others have many powers, immunities and privileges which ordinary citizens do not have. For example, the President, Governor is not answerable to the court of law in discharge of his executive functions. No criminal proceedings whatsoever can be instituted against the President or Governor of a state while he is in office. No civil proceedings in which relief is claimed can be filed against the president or governor except after an expiration of 2 months' notice that is served on him. Under international laws, the visiting heads of the state, heads of the government, ministers, officials, foreign diplomats who are posted in the country are not subjected to the jurisdiction of local courts in discharge of their official functions. Dicey propounded individual liberty and criticized administrative discretion, but he failed to distinguish between the discretion given to public officials by statute and arbitrary discretion claimed by the king. If giving discretionary power to the government departments and public officials is against the rule of law, then rule of law cannot be made applicable to any country in the modern world. The rapid advancement of technology in the modern world has also brought new challenges with it. New technologies are changing the lives of the people around the world. Technology has an immense untapped potential to strengthen the rule of law. Technological innovations can provide equal access to justice, help to eliminate discrimination, and assure the more transparency and accountability. A.J. Mohammed, Deputy Secretary General of United Nations, introducing the report, said that digitalization can advance access to justice by creating more streamlined processes. However, this depends on equal, reliable internet access. She pointed out, and also noting that while technology can enable progress, and it can also amplify inequality, if technological tools are not developed and used in a manner compliant with the human rights, they can even lead to harm, she warned. Some more challenges for the rule of law with the advancement in technology are privacy and surveillance. Balancing the national security with individual privacy rights is increasingly complex in the digital age. Cybercrime. Legal systems struggle to keep pace with the rapid evolution of cybercrimes and digital fraud. Artificial intelligence. The use of artificial intelligence in legal processes raises questions about the fairness, transparency, and accountability. The prevalence of rule of law is precondition for the democratic governance of both intrastate and interstate systems. It has compelled the United Nations Secretary General in his speech in 2004 to the UN General Assembly to remind the international community that every nation that proclaims the rule of law at home must respect it abroad. And in every nation that insists it on abroad must enforce it at home. The realist school of international relations contends that rule of law is observed as long as it serves the national interests of a state. There exists the iron law of politics that legal obligations must yield to national interests. International politics is, from the realist perspective, all about the accumulation of power, both as the means and as an end. Therefore, where the idea of rule of law and national interest clash, the latter always triumphs. This is a global challenge for the rule of law. We can conclude by saying that future of rule of law depends upon addressing the challenges explained above and adapting to new realities. Key considerations include, first, strengthening the institutions like judicial independence. Safeguarding the autonomy of judiciary is crucial for upholding the rule of law. Secondly, anti-corruption measures. Implementing robust anti-corruption frameworks can restore public trust in legal institutions. Thirdly, inclusive legal systems. Ensuring that marginalized communities have equal access to justice is essential for a fair and just society. Adapting to technological advances. Regulating artificial intelligence and digital platforms. Developing legal frameworks for artificial intelligence and digital platforms can ensure they operate within the bounds of law. Protecting digital rights. Updating laws to protect privacy and digital rights is crucial in the age of information technology. Promoting international cooperation. Strengthening international legal institutions and addressing global challenges like climate change, cybercrime, and human trafficking can enhance global adherence to the rule of law. The realist school of international relations, which represents a dominant approach to international relations, contends that the rule of law is observed as long as it serves the national interests of a state. Therefore, where the idea of rule of law and national interest clash, the latter always triumph. Fostering legal education and awareness. Civic education. Promoting legal literacy among the citizens can empower them to assert their rights and hold authorities accountable. Professional training. Continuous training for legal professionals ensures they remain updated on new legal developments and technologies. At the end, I would like to say that today, the concept of rule of law is more comprehensive. It is a dynamic concept that is not merely to safeguard and advance the civil and political rights of the individual in a free society, but also to establish the social, economic, educational, and cultural conditions under which his legitimate aspirations and human dignity may be realized. Thank you.